Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about the Gyanvapi mosque controversy. At the same time, we are also going to discuss about that what is the Places of Worship Act. So let us start and try to understand first of all the context in which we are discussing today's issue. So recently the Supreme Court has decided that it will hear a challenge today, that is on Tuesday, against the order of a civil court of Varanasi. So what is this order was? This order was that the civil court in Varanasi actually have directed to conduct a videographic survey of the Ma Sringar Gauri Asthal that is located in the complex of Kasi Vishwanath Temple and Gyanvapi Mosque. Now, this against this order, there is an organization that is called as Anjuman Intijamiya Masjid, and the committee of management of this organization has said that the order of the Varanasi court, which also was earlier upheld by the Allahabad High Court on April 21st, it says that it is in direct contravention or it clearly interdicts the Places of Worship Special Provision Act of 1991. So since this order is in contravention to this particular act, it should be struck down by the Supreme Court. So this is the whole context of this issue. Now let us try to know about slightly about the background of this whole issue. So actually earlier, before the civil court granted the order, a petition was filed by 5 Hindu women who wanted to have a order passed by the court to have a round the year access to pray in the Gyanvapi Mosque complex. Currently, it is a shrine. Now talk about where they wanted to pray. So they wanted to pray to a shrine that is located behind the western wall of the mosque complex. As of now, currently it is open for Hindu prayer only once a year, that is on the 4th day of Chaitra Navratri in April. So instead of one day, these 5 Hindu women wanted to have access throughout the year so they can offer prayer to the prayer in the shrine behind the mosque complex. Now what is the history of Gyanvapi? So Gyanvapi is believed that the mosque was actually constructed by the Mughal Emperor Aurangzeb in year 1669 after the demolition of existing temple that is called as Vishweshwar Temple. And it is also has been the same point has also been referred in a very noted book that is called as History of Benares from the earliest time down to 1937. This book is a very popular book and is written by A.S. Altekar. A.S. Altekar was a very noted historian as well as the professor of history at the Banaras Hindu University. Now, what this book also mentions, or also what historical record mentions, that when Mughal Emperor Aurangzeb demolished the Vishweshwar Temple to construct Gyanvapi Mosque, the plinth of the temple and one of the wall was actually left untouched. The plinth of the temple that was left untouched later on converted into courtyard of the mosque, and the wall that was left untouched, that became one of the most important wall that is referred in mosque as a Qibla wall. This wall is actually very ornately designed and also is actually, and this wall is oriented toward the direction of Makkah. That makes it a very, very important wall. Apart from that, what we know about Gyanvapi is that whatever material that has been that actually was taken from the destroyed temple, the same material has been used to build the mosque. Now, from where does the name Gyanvapi comes? So Gyanvapi actually is a name that is believed to be derived from a well that has dried up as of now. The well was called as Gyanvapi, which roughly translates into English as the well of knowledge. Now, apart from that, one more point that should be noted here, and that is also how people believe that actually this mosque used to be a part of temple complex, is the orientation of the Nandi bull. The statue of Nandi bull, which is currently situated in the Kasi Vishwanath Temple, it currently faces the wall of the mosque. Generally, if you look at the temple architecture of India, the Nandi Bull's statue actually faces toward the Sanctum Sanctorum. But in this case, instead of facing the Sanctum Sanctorum, the Nandi Bull statue is facing the wall of the mosque. And that is why many people believe that in earlier time, this bull was facing the actual Sanctum Sanctorum of the temple, which has been demolished and constructed, or we can say reconstructed into mosque by Aurangzeb. So this is also one of the point which people want to portray to prove that actually Gyanvapi used to be a temple. Now, if we try to look at the orientation of and location of all these complexes, so here you can see this is the Sri Kashi Vishwanath Temple that is in the red line, and just to the south of, to the north of, we can say, or to the east and west of this Kasi Vishwanath Temple, we have the Gyanvapi Mosque or Gyanvapi Masjid. So let us try to understand about this temple, that is this Kasi Vishwanath temple. So after the construction of this mosque by Aurangzeb in 1669, for hundreds of years there was no such temple in these areas. It is believed somewhere in the 18th century, the modern Kasi Vishwanath temple has been constructed by the Rani Ahilyabai Holkar of Indore. Gradually, it became one of the most prominent and revered centers of the Hindu religion. And original lingam of the erstwhile Visveswar temple is believed that when Aurangzeb attacked and wanted to demolish the temple, it is believed that the original Sivling was actually hidden by the priest of the then Visveswar temple inside the Gyan Vapi well. And this well, this is where today people are claiming that the Sivling is still lying in the complex of Gyan Vapi mosque, and on basis of that actually the whole video recording and everything is going to be conducted. Now in this context, a very important act that we have discussed in the beginning also, on the basis of which actually the committee has said that the current order of the court interdicts the act. That act is the Places of Worship Special Provision Acts of 1991. So let us try to understand about this slide in a brief. So what does this act say? This act actually aims to prohibit conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on 15th day of August 1947 and matters connected therewith or incidental thereto. Now this whole thing has been summed up in 4 different sections. So first important section of this act is section 3, that bars the conversion, whether in totality or partially, of any place of worship, no matter to which religious denomination it belongs to, into a place of worship of different religious denomination. That means a temple cannot be, we can say, converted into mosque, mosque cannot be converted into temple, a temple cannot be converted into, we can say, church, and so on and so on. Then the next important act is section 4, subclause 1, which says that the religious character of the place of worship shall continue to be the same as it existed on 15th August 1947. That means if on the 15th August 1947, if the religious character of the place of worship was mosque, it will remain a mosque in the coming days, in the coming future. Then another important section is section 4, subclause 2, which says that any suit or legal proceeding that existed on August 15, 1947, no matter to which court it was pending to, shall abate and no fresh suit or legal proceeding shall be instituted as far as the religious character of place of worship or conversion of religious character of place of worship is concerned. However, one exception has been made in this particular act, and that exception is with regards to the Ayodhya temple. Here, the section 5 of the same act clearly mentions that the act shall not apply to the Ram Janmabhoomi and Babri Masjid case and to any suit, appeal or proceeding related to it. So the Ram Janmabhoomi, or we can say Ayodhya temple, was the only exception on which this act has not been applied. However, the court has categorically stated before that on all the places of worship this act will be applicable. So what is the grounds of challenge of this particular act? So as of now, 2 petitions are there that is challenging this particular act and are right now pending before the Supreme Court. The reason why this act has been challenged is because of the first judicial review, which is considered as a basic feature of Constitution, and it says that this act does not talk about any kind of judicial review, and that is why it should be struck down. The second point is that the act has arbitrarily and irrationally fixed a retrospective cutoff date of 15th August 1947 and does not allow conversion of any religious place of worship to, depending on the merit of the case, into the another religious place of worship. So that is arbitrary and irrational as per the petitioner. And third point that is mentioned by the petitioners is that this act actually abuses the right to religion of Hindus, Jains, Buddhists and Sikh community, as it does not allow them to offer prayer or to convert their actual place of worship, which has been converted into a mosque or something like that. So these are 3 points or 3 grounds on the basis of which the Places of Worship Act has been contested about. So when actually this act came into existence? So this origin of this law we can trace back to 1991, when the country was led by P.V. Narasimha Rao government. During that time, it was Ram Janmabhoomi matter was very much charged. That time we have Sri L.K. Advani, who was conducting Rath Yatra all across the country, and later on he was arrested in Bihar, and then there was firing on the car sevaks in Uttar Pradesh. All this led to a very communal, tense environment in the country. And under this communally tense environment, the then Home Minister S.V. Chauhan has said that it is considered necessary to adopt these measures in view of the controversies arising from time to time with regard to conversions of places of worship which tend to vitiate the communal atmosphere. So that the communal tension does not flare up or the communal atmosphere does not become bad, the enactment of this act is very, very crucial. That was anyway the rationale given by the then Home Minister, and that is when the act was enacted. So what the Supreme Court actually has said on this particular act, especially in reference to Ayodhya judgment. So first of all, we have to understand that as far as the Ayodhya judgment is concerned, the constitutionality of the 1991 Act was never challenged, neither was it examined before the Supreme Court bench. However, the Supreme Court has, in the point it has noted that the Parliament determined that independence from colonial rule furnishes a constitutional basis for healing the injustices of the past. And that is why the act has been designed or act has been enacted with the spirit to provide the confidence to every religious community in the independent India that their places of worship will be preserved and their character will not be altered. So that is how the Supreme Court has interpreted the spirit behind the passage of this act. So what conclusion can we draw from this particular judgment? So first we can understand the Supreme Court actually has clearly stated the state has, by enacting the law, enforced a constitutional commitment and operationalized its constitutional obligation to uphold the equality of all religions and secularism. This is very, very important point, which is part of the basic features of the Constitution. That means the passage of this act or the enactment of this act is basically aimed to uphold the values of secularism as well as the equality of all religion, which is a basic feature of Constitution. And the Supreme Court has noted that the Act actually provides a non-derogable obligation toward enforcing our commitment to secularism. Thus, what we can conclude by saying is that the Places of Worship Act is a legislative intervention which preserves non-retrogression as an essential feature of our secular values. That means indirectly Supreme Court has upheld this act. Now we have to see how all these things and all these incidences play out, what the videographic survey that has been conducted, how it is interpreted by different courts, and how the Supreme Court take cognizance of this matter. So we'll come back soon when the new development and interesting important development happens in this case. Till then, take care. Thank you very much.